off. Okay, so we are almost finishing. We are on the last topic. I think what is remaining in the workshop and organization unit is the work study. In the work study, we will be calculating the rate of payment of somebody, the piece rate. How are you supposed to determine what to pay somebody? For example, if you have employed people in your farm and these people are working maybe for a certain specific task, how will you pay these people? Are you going to pay them per hour? Are you going to pay them per day or per given task? So we will be calculating and know how to be able to know how to pay your workers. Or if you are one of the workers who has been employed, you'll know your rights and know how you're supposed to be paid. So the labor rights, one of the common thematic areas in Kituo cha Sheria that is operates the pursuit division of just equitable society. That is being through legal advice and litigation, as well as through policy advocacy and education. So during this period, the Kituo cha Haki has revised numerous complaints from workers regarding the terms of the condition of employment. Regarding the terms and conditions of employment, this is Kituo cha the experience that ordinarily Kenyans worker lacks basic knowledge about this, his or her rights as a worker. So as workers of the nation, Kenya nation, people are supposed to be aware of their rights as a worker. What if something happens at your workplace, or if you are fired abruptly, what are you supposed to do? There are steps that are organized or are structured by the law to be able to govern the workers. So this booklet is designed for workers, employees, as well as anyone else who wants to know and understand the law in Kenya as it relates to labor and the labor relations. So in the year 2007, there was a review of the national labor law, which had been concerned both Kenyan's public and the government for a long time. So these arose out of the tremendous changes experienced in the local labor market, such as the structural adjustments, liberalization and the economy, and the technological innovations. So the review was aimed at ensuring the laws were responsive and contemporary economic and social changes, as well as achieve a new set of reformed update labor regulations through the coordinated consultative process. So the following are 6 core labor status that were comprehensively reviewed and reappealed in the process. So we have the Employment Act, which has normally been there in our constitution. We have the regulation of wages and conditions of employment. What are the conditions of employment of a person? When you are employed, what are the working environment? You remember that the constitution requires that all working employment environments should be provided by adequate water supply and aeration to be able to and even the utilities like washrooms, enough washrooms and running water. Those are some of the requirements that the law requires for employers to be able to put in their working places. We also look at the Trade Unions Act that were there in the Constitution and the reviewed ones, the Trade Disputes Act, the Factories and Other Places of Work Act, and the Workman's Compensation. So after the review, the exercise have 5 new pieces of legislation were enacted. These were, you have the Employment Act and the Labor Relations Act. Okay. So I'll move forward. So these are some of the terms that we'll meet when we'll be discussing these things, and we'll define this definition so that we'll be able to all be aware. So inside this document, we'll get definitions like a child, and a definition of a child is any person that is under 18 years of age. And we have another thing called a collective agreement. A collective agreement is a registered agreement concerning any terms and conditions of employment, apprenticeship, or an indentured servitude made in written between a trade union, an employer, a group of employers, or employers organization. So that is a collective agreement. These are the agreements that normally we see our unions come into agreement with like the colleges and universities union. We have the unions like the TAC, the NAT, and so forth. Contract of service. It is an overall or written agreement to employ or to serve as an employee for a period of time. So a contract of service can either be oral or written. For example, you have gotten a client at your home, and your client wants you to do an electrical installation or some repair, or some maybe fault finding of maybe a problem, the lighting circuit in the house. So the contract that you enter into most cases will be an oral contract, because it will not be such a detailed contract to be able to get into the written agreement. But when a serving agreement is going to take things like something like maybe a month or a year, months, more than 3 months or a year, it has to be a written contract agreement. Is normally written, known as a written contract, to be able to bind these two people together. And remember, in estimation and tendering, we started by looking at a contract. What is a contract? We said a contract is a binding agreement. It's a binding agreement that has the consent of both parties, and it has to have two or more parties. So you cannot enter into a contract as a person. The contract has to be entered by two or more people. So when two people agree, we say the contract has to have an agreement, consent, and the capability. So this person who is getting into a contract must be capable or must show capability of performing the contract. If somebody is not in a position or does not have a capability, for example, you're given a contract for a 4-story house, maybe a 52 units, to do electrical installation, and you sign a contract. Then this person signing a contract with you must have seen that you have the capability, maybe financially, or you have the materials, or you even have the skills or the knowledge to be able to do the task. So that is the contract of service. Disability is one of the terms, again, we will get to look at here. A disability is the physical or sensory or mental incapacity. So somebody who has a disability physically, sensory, meaning cannot sense something, and then mentally, also mentally incapable. These are people who are insane. So these are people who have special cases in entering into contract with, especially for the employment. And who is an employee? An employee is a person that has been employed for wages or for a salary, and includes an apprentice or indentured learner. So somebody can be maybe on internship or attachment, or apprentice. Apprentice is somebody who is learning on skill. Let's say, for example, you have a workshop somewhere, or you have a work or a contract that you've been given, and then you bring up some two people to assist you, like laborers, and then you train them on skill. Somebody just come. So that is called an apprentice. An employer is any person, including the government, who employs or has employed an employee, and where appropriate includes a hearer, a successor, a signee, a transferer of an employer, or an agent or a director of any person authorized to represent the employer. So forced or compulsory labor. These are some of the terms I said that we need to understand. Forced or compulsory labor, what does it mean? All work or service which is extracted from any person under the menace of any penalty, and for which the said person has not offered himself or herself voluntarily. It excludes compulsory military service. So forced labor, this is when you force somebody to work against the will, meaning you are making somebody maybe to work overtime, and because the person has no capability of saying no, so it's called forced labor. Redundancy. What is redundancy? Redundancy is the loss of employment through no fault of the employee. This is when an employee loses a job without doing any problem. But typically, this termination is due to the employee service being unnecessary as a result of downsizing. A good example is when this COVID-19 pandemic came on board, and it struck most companies and most organizations, where some of the jobs were not done, and it rendered so many employees redundant. A redundant person is somebody whose contract is terminated, not because the person has done anything wrong, but because the service that the person was offering is no longer being offered. So the person will have to be dismissed because of redundancy. Remuneration. Remuneration is the money paid to a work of service. When somebody has worked for a certain job or has worked, the person has to be remunerated or paid. So remuneration is all about money. Trade union. Trade union is an association of employees whose principal purpose is to regulate regulations between employees and employers, including the employer's organization. And then we have summary dismissal. What is summary dismissal? You will hear some of these terms. Summary dismissal. It is the termination of employment by the employer with no prior notice or with less notice than prescribed on the contract of service or by law due to the employee breaking his or her agreement under the contract of service. Summary dismissal normally does not come with a warning. And it is normally instant. When you have entered into a contract with your employer and the employer needs you to do something, and then there comes in something like a conflict of interest, or you do what you didn't agree on the contract service, then the employer has the liberty to do a summary dismissal where the person dismisses you at any time without warning and without notice. Then a permanent disablement. What is permanent disablement? This is when somebody gets something called a permanent injury or disfigurement, maybe at his place of work, maybe through a machine. A machine maybe amputates an arm, maybe a running machine cuts off or makes the person permanently blind or permanently deaf, or cuts off the limbs like the arms or the legs. So this is called the permanent disablement. This is a disablement that cannot be put back. Then temporary disablement. This is a temporary condition that took place while at work, which results in the loss of wage earnings capabilities or at the workplace. That is self-explanatory. So we are going to go through all those. It's a long document, but it's a very important one. So labor law in Kenya is derived from several sources, including the Constitution, Acts of the Parliament, the subsidiary legislation, the International Convention. This booklet will briefly highlight the significant laws as they relate to the workers. So while we recognize that many questions and issues relate in the labor are complex and may require further information, it is our belief that the basic education about labor laws in Kenya. There are several major sources of law governing employment laws in Kenya. We have the Constitution. The Constitution, that is Article 27, provides for the right to equality and freedom of discrimination. So it states that women and men have the right to equal treatment, including the right to equal opportunities in political, economics, cultural, social spheres. So this is from our Constitution of the Constitutional State, and the state shall not discriminate directly or indirectly against any person on any ground, including the race, the sex, the pregnancy status, the marital status, health status, ethnic, social origin, color, age, disability, religion, conscience, belief, culture, dress, language, or birth. So the Constitution states that there should be no discrimination whatsoever for that. And most specifically, Act 41 provides the labor relations. It states that every person has the right to fair labor practices under the Constitution. Every worker has the right to fair remuneration, a reasonable working condition, and a form to form, join, or participate in activities and programs of the trade unions, or to go on strike. So even going on strike is on our Constitution, and it allows workers to be able to even go on strike. So the procedure of going on strike is clear. It is, however, not provided for in the Constitution. So the employees are required to provide due notice to the employer on their intention to go on strike. So, and the reason behind their such action. So once the notice is expired and their grievances have not been met, so the employee has the right to proceed with the strike. The Constitution also provides for the rights of the employee. Every employer has a right also to form and to join employers' organization, participate in the articles and programs of the employers' organization. The rights of a trade union and employers' organization have also been laid out to determine their own administration, programs, and activities, to organize, that is, and form and join federations. Number 2 is the Employment Act. This act establishes the minimum terms and conditions of employment. That is, the act sets forth the relationship between an employer and the worker. It defines the benefits, duties, and obligations of the employer and the worker, which includes the contract of service, the prohibition against forced labor, discrimination in employment, sexual harassment, payment of wages, leave, termination, and living amenities. Labor Institutions Act is also another one. It's an act that establishes National Labor Board, that is the Committee of Inquiry, Labor Administration and Inspection. So the Wages Council and employment agencies which work to enhance the institutions and bodies that establish the regulations that govern Kenyan labor relations. So the Act provides definitions for correlative agreement, contract of service, terms embedded with the labor laws. Another one is the work injury benefits. The law also outlines the work injury benefits. This act provides for International Labour Organization Convention compliant laws pertaining to employee compensation in the workplace. That is, following enhancement of this act, many of the sections were annulled by the High Court, finding them unconstitutional. Okay. Labor Relations Act will continue. We say that the Act is primarily concerned with the Federation Association for the employees and employers and the right of collective bargaining. So the Act provides legal guidelines for the establishment of the trade union, the employers' organization of their functions. So the Occupational Safety and Health Act of 2007. The objective of this act is to provide the legal framework for employers to maintain healthy working conditions. Please mute your mic. Salad, unless you have a question, okay, we proceed. The Occupational Safety Health Act is also an act that is in our Constitution. The objective of this act is to provide the legal framework for employers to maintain healthy working conditions and environment for their workers. The act makes provision for the safety of the health of the workers in Kenya workplace and establishes the National Council for Occupational Safety and Health. We have also the Industrial Code Act. The Act establishes a revamped industrial code that is the same status of the High Court as exposed in the Constitution of Kenya. So the Industrial Code is established as the court of superior record. That is the court that is given powers to adjudicate over cases of employment and labor relations. So it describes the qualification, remuneration, the security of tenure, and the judges of industrial courts. So it further establishes an employment and labor relation rules. So international convention and treaties, I will not talk about that. Types of workers. So I wanted to go straight to this. Types of workers. Workers may be classified into three main categories. We have permanent workers. Permanent workers, these are persons who sign a written employment contract that identifies he or she as a permanent worker. It also includes a person who does not have a written contract but who is paid at the end of 30 days. It's called a permanent worker. So is expected to work for a probation period, generally for 1 to 3 months before he or she is confirmed and can claim benefits. So it's required in the event of resignation to give at least 1 month notice or 1 month salary in lieu of notice. So for a permanent worker, this is a worker who is permanent, and when this person wants to terminate a contract or wants to go away, he'll have to give a 1 month notice to the organization. The event of termination is entitled 1 month notice or 1 month salary in lieu notice unless the worker is dismissed summarily. And then a casual worker. Who is a casual worker? A casual worker is a person who works for a short period of time, generally not more than 24 hours at a time, and is paid at the end of each day. That is a casual worker. So has no guarantee of being employed more than 24 hours and can be dismissed at any 1 day's notice. So a casual worker can wake up in the morning and can be told that there's no work for you. So that is a casual worker. And we have a fixed term contract workers. So is a person employed for one determined fixed period of time, which is more than 1 day. Entitlements and are determined by the terms of contract entered with the employer or declarative bargaining agreement. So an employment of 3 months or not longer should have his or her contract written. And underlying principle of employment. Just give me some minutes, Alad. Okay, sorry, Salad, I'm back. I was just attending to an urgent matter. Okay, let's proceed. So we have differentiated between a permanent worker, a casual worker, and a fixed-term contract worker. So what are the underlying principles of employment? The relationship between a worker and an employer is based on the contract. That is, both the worker and employer should agree upon the terms of employment, depending on which type of worker the person is. So before the worker begins his or her term of service, they should agree. So if a worker joins a union, the terms of employment may be negotiated as part of the collective bargaining agreement. So it's important to know that an employer cannot impose terms of employment on a worker that have less than minimum terms required by the law. So every worker hired for a sum of 3 months or more must be given a written contract of employment by the employer. So it is a legal obligation of the employer to draw up the contract. So to sign the worker's consent, both the worker and the employer must sign the employment agreement or imprint an impression in her or her thumb or any finger in front of someone other than the employer. Legal duties of every worker. What are the legal duties of every worker? Now, every worker must adhere to the following. Muka. Muka kasoma je. Hebu muamshe. Poa sana. Okay, we proceed. Arrival at work on time and carry out his or her assigned work fully and responsibly. Perform all lawful tasks or assignments that are written the scope of worker's job description. Not drink alcohol or other intoxicating or illicit drugs during work. So those are some of the duties, legal duties, and not use abusive language or behavior in the workplace. Discrimination in employment. What does the law say about discrimination in employment? In Part 2, Section 5 of the Employment Act states that no employer may directly or indirectly discriminate against an employee or potentially employee or harass an employee or potential employee in the ground of race, color, sex, language, religion, political or other opinions, nationally, ethnic, or social origin, disability, pregnancy status, or that. So no employee is supposed to be discriminated against. That is the law. Now you can see that picture here. Discrimination of employment of other matters arising from employment. Now, you can see a picture here where Mdosi is there and is talking to an employee. And the Mdosi is telling the employee that you are fired. I don't like your stupid tribe, your religion, political alignment, or your HIV status, and your stupid, silly husband. Get out. So that is called discrimination, and it's not allowed. So, sexual harassment. The law states that every employee is entitled to employment that is free of sexual harassment. So, an employee is sexually harassed if their employer, a representative of the employer, or a co-worker commits any of the following. Number one, directly or indirectly request sexual intercourse, sexual contact, or any additional form of sexual activity that contains the implied or express promise of the special detrimental treatment in the workplace or treatment of the current or future working status of the employer. So, sexual harassment is one of the things that is very bad for an employer to impose on an employee. So it can either be even a gesture or a signal, which is not allowed. And then another thing is the use either of written or spoken sexual language. It's not allowed. Another one is the use of visual material or sexual nurture. It's also not allowed. Then jeopardize and job performance, job satisfaction or general well-being of the employee in the workplace by displaying direct or indirect physical or sexual behavior that is unwanted and insulting. So you can see the Mdosi here, whatever the Mdosi is doing, that is saying that, hi Sweetie, how do you like it over a promotion? You've got nice supporting documents. So this is not allowed by the Constitution. So if more than 19 employees reside in a single workplace, so the employer must consult the employees or their representatives if they exist and issue a policy statement on sexual harassment in the workplace. So this document must be brought to the attention of each employee and must include the following information. Number one, a definition of sexual harassment as specified by Part 2 of the Section 6 of the Act. That is assessment explaining, number one, every employee's rights to a sexual harassment free workplace with the assurance that the employer will take all necessary steps to make certain that no employee is subjected to sexual harassment in the work facility. In the event that an employee is subject to sexual harassment, the employer will take disciplinary action as deemed appropriate. So how to bring issues of sexual harassment in the workplace to the attention of the employer. So the employer will keep all names included in the reports of possible sexual harassment confidential unless disclosed if necessary for the purpose of investigating. They say that low-cost laborers, these are people. I hope I'm clear. Please, Salad, confirm that you can get me.
Yes.
Okay.
Kuna wakati inakatakata lakini saa iko sawa.
Nime sense kuna network problem, but at least hii niko sawa.
Yes.
Sawa, let's continue. So prohibition against forced labor. We say that forced labor is forcing somebody to work who cannot say no. Employing children is not allowed. Somebody who is less than 18 years cannot be employed for pay. You cannot employ somebody who is less than 18 years to pay. So that is called forced labor, and it's not allowed by the Constitution. The law states that it is illegal to use or assist any person in the recruitment, purchase, or the sale of used forced labor. This includes the recruitment or compulsory employment of children. Children should not be employed, they should be nurtured and they should be taken care of. They should not be employed. Wages and salaries. Now, wages and salaries. We said wages and salaries, this is remuneration. So under the law, every worker is entitled to receive full payment of work done. So full paid pay includes wages, which are payments made on an hourly, daily, weekly, or a piecemeal base. So full pay may also be in form of salary, which is fixed payment made on a monthly basis for professional or office work. So the amount of full pay cannot be less than a standard minimum rate, which is set forth by the Employment Act. So Employment Act has also set a rate at which employment money or wages should be given. So on the date of payment, the employer must give each worker a payslip stating all earnings due and their deductions made for that pay period. So all wages must be paid in Kenyan shillings. However, a worker can request in writing that the employee pay wages either by check or by crediting the wages to the worker's bank account. So when the worker is absent, the employer, with permission from the worker, may pay the wages to another person appointed to the worker. Generally, payment is on working day and during working hours. So wages must be paid at a near or near the place of employment or at the place agreed between both parties. So this place of payment cannot be the place where intoxicating liquor is sold and available for supply, except for parties employed to work in such establishment. However, exceptions may apply in the following situations. Now, like for example, the piecework is paid at the end of the month is in proportion to work completed, and then another one is a casual worker is generally paid at the end of each day unless the worker requests otherwise. And then if employed for a period exceeding a month, then payment due is at the end of each month. And then workers' employment for the undefined length of time, that is, payment is due at the end of the agreed contract or at each end of the month. So in case the summary dismissal wages are paid up to the date of dismissal, in addition to the wages, every permanent worker is entitled to a housing accommodation or housing allowance. So the rate of housing allowance are found in the current year's wages order. You can see our constitution has structured well the wages and salaries, how they're supposed to be given people. So you guys, when we release you to the environment, when we release you to the market, you should have this knowledge. You land on employment, and you should know your rights. You should know that the constitution protects your rights as an employee, and you should know how to defend your rights. Deduction of wages. When can deduction of wages be done? Now, other than the statutory deduction, an employer is generally not allowed to make any deductions from the employee's wages. However, there are several exceptions. Now, if a worker is absent from work without leave, now the employer can deduct wages equal to amount of time when the worker did not work. Another thing is an employer may deduct any contribution by a worker to his or her retirement or provident fund. Another one is a worker damages, stroke losses, goods or money at the workplace, and the employer may deduct the value of the lost goods and money from the worker's wages. Salary advances and loans can be deducted from the worker's wages as well. So you can see this. Now the worker is asking, by the way, I forgot to deduct a further 1,000 shillings towards my distant cousin burial. It is not allowed. You cannot deduct from the payslip of a worker such costs because they are things that the person pays at will. So note that an employer may not make deductions from wages as a form of punishment. Moreover, the total amount of deduction in a wage period shall not exceed 2/3 of the worker's total wages. Statutory deductions. Every employer is required by law to deduct each of the workers' wages a certain amount required to pay, that is the National Society Security Fund, which is the NSSF, and the National Hospital Insurance Fund, which is the NHIF, and the pay as you earn. This is pay. Pay is called the pay as you earn, which is money taken by the KRA, by the tax. This is called the personal tax. So these are some of the statutory deductions are the deductions that must be done by every employer. So National Security Fund (NSSF) is a social security measure that encourages workers to save proportions of their present earnings and contribute it to the retirement or their pension fund. Both the workers and the employer are required to contribute to the fund. So all the payment permanent workers must pay contribution to NSSF. At a time of printing, the worker and the employer contribute 200 shillings, totaling to 400 shillings towards the NSSF. So if you are contributing 200 shillings, then your employer also contributes for you 200 shillings, and it becomes 400 shillings. So generally, casual workers do not benefit from this scheme and therefore do not have to pay into it. So in addition, NSSF government employees are also entitled to participate in the government pension scheme. So a worker is entitled to receive payment from the NSSF fund after he or she reaches at the age of 65 and has retired from the regular employment. However, a worker can now access his or her NSSF contribution before the retirement age by supplying a letter of appointment, termination letter, and a declaration that is not able to continue making contribution. As a worker who is forced to retire because he or she is suffering from physical or mental incapability can also benefit from this fund. Now, every employer is obligated to pay into the fund both his or her workers' contribution. So if an employer fails to make these payments, he is guilty of a criminal offense punishable by law. So if an employer, somebody who has employed you, deducts your NSSF but does not submit it to NSSF, then he can be punished by the law. So a worker should immediately report the offense to the NSSF headquarters, which is located in the Social Security House, Bishops Road at NSSF building, the Nkrumah Road, or Mombasa, or any other provisional offices. Every worker has the right to know if his or her employer has paid into the fund and may write the NSSF to confirm the employer's payment. Note that this is a statutory requirement for any employer who employs 5 or more workers. Pay as you earn. What is pay as you earn? Pay as you earn. This is every employee's legal duty to deduct income tax from the pay of the employees. Thus, all employees, whether paid weekly wages or monthly salary or annual salary or bonus, etc., must pay this tax. So, for example, in the year 2001, any permanent worker whose gross payment exceeds 9,600 shillings is subject to this tax. So in addition, casual workers who are employed for 1 month or less do not have to pay this tax. Any employer who does not deduct pay from workers' wages is committing a punishable offense, and these income tax deductions must amount to set each year and can be obtained at the government printers. So note that this is statutory requirement. National Hospital Insurance Fund. It is also another statutory deduction. All workers can make contributions to this fund to offset medical bills for the workers when a worker is admitted as an inpatient at any hospital, nursing, maternity home that has been recognized by the government under this act. So the worker who contributes this fund is issued a national hospital insurance card for each financial year, so which will show his up-to-date payments. So the employer retains this card and should remit any contribution to the fund promptly every month. So the proposed NHIF contribution that at the time of print raised a lot of controversy, that is less than 5,900, and this will pay 150 shillings. Over 100,000 will pay 2,000 shillings. Self-employed pay 500 shillings. Ingredients, indigent, that is voluntary, 300 shillings, and the current contribution monthly flat of 320 shillings. Working hours. You realize that there are so many things involved in working. There are so many things or regulations that are involved in the work labor. So working hours. The normal working hours shall be 48 hours during a 6-day work week, 8 hours per day. Now, certain types of workers, such as watchmen, herdsmen, caretakers, may require to work up to 10 hours a day or 6 hours a week or 60 hours a week. Generally, child labor is prohibited. However, a child may be engaged to work where the work benefits the child's education and well-being and does not interfere with his or her education. A child who is age 16 or younger should not work more than 6 hours in one day. So every worker must be given at least one full day of each week for rest. So it is allowed that every worker must be given a full day to rest. Overtime payment. Overtime is any period worked in excess of the regular working hours. So how is it paid? An employer must give the worker 24 hours notice for overtime request. So a worker cannot be forced to work overtime and should be adequately compensated for any overtime work. So overtime payment is one of the half-time of workers' normal hourly rate. Time worked over the normal workings in the worker's normal rest day, a public holiday, overtime pay is twice the normal hourly rate. So for public holidays, the overtime is twice, but for normal working days, it is a half the time. So if the worker is not employed by the hour, so the basically hour rate is deemed to be 1 or 200 and 2/5, that is 1/225 of the employee's monthly wage. So a worker cannot be asked to work more than 116 hours in a consecutive 2-week period. For nine for night workers, it should not exceed 144 for consecutive weeks. Now, an employer can offer time off in place of overtime pay if the worker agrees in writing. Types of leave. This is also another important section. Types of leave. We have annual leave. Annual leave. Every employee is entitled to at least 21 working days of leave after completing 12 consecutive working months. That is annually. If an employee is terminated after working for at least 2 consecutive months, he or she is given at least 1 3/4% days pay leave of each completed month of work. So a worker is not entitled to this leave if he or she is similarly dismissed. Public holidays and sick leaves days are not counted as leave days. So public holidays with a full pay are New Year's Day, Day, Easter Monday, Labor Day, Madaraka Day, Eid Fitri, Mashujaa Day, Jamhuri Day, Christmas Day, Boxing Day, and any gazetted public holiday. So such industries such as the hotel, catering, security, and others give workers a leave traveling allowance. So sickness and sick leave. What is a sick leave? A worker who becomes ill while at work should take all reasonable steps to inform his or her employer of the illness. Once the employer is informed of the worker's illness, the employer must provide him or her with a proper medical attention. After completing 2 consecutive months of work, a permanent worker is entitled to at least 7 days of fully paid sick leave. Thereafter, the worker is entitled 7 days of sick leave with half pay. So to obtain paid sick leave, a worker must produce a certificate of incapacity to work signed by a qualified medical personnel. So if a worker has an accident while at work and the accident is not due to worker's willful misconduct or neglect, the worker must pay the employer must pay the worker the full salary for the period he or she is absent from work until the worker is certified incapable of returning to his or her employment. Another one is maternity leave and paternity leave. A woman has a right to take 3 months maternity leave with full pay. To be entitled such as rights, a female employee must give written notice not less than 7 days in advance at which the date which intends to leave and return to work. A woman who has taken maternity leave cannot in the same year claim annual leave unless the employer agrees in writing. So a woman taking maternity leave does not lose any of her benefits or a previous job during that period. Male employers also have the right for 2 weeks paternity leave with full pay. Healthy and safety in workplace. The employer must provide a clean, safe working condition environment for the workers. That is, every factory must keep clean and free from all forms of sanitary nuisance. Every factory worker is entitled to the following working condition. That is, access to an adequate supply of clean water, sufficient fresh air and adequate ventilation, sufficient and suitable lighting, sufficient sanitary facilities like the toilets, washroom, adequate accommodations, in-store clothes, worn-out working hours, freedom from overcrowding in the workplace, suitable seating facilities for workers whose work is done standing. First aid materials, that is, all equipment and machinery must be of sound quality and adequately fenced off to protect workers using or working near such machinery. The employer must establish and make known to all employees clear rules of handling dangerous substances such as poisonous pest control products. Such as rules must be in a language that all employees can read and understand. So in addition, employees must make sure all dangerous and poisonous substances are properly labeled, packed, stored, handled, used, and disposed of. A chemical safety data from every dangerous substance must be provided, and then provide a protective clothing including gloves, footwear. Those are health and safety at the workplace. Uh-huh. So you can see adequate instruction and train workers in use handling poisonous and dangerous substances and equipment. So make first aid facilities available in dealing with the emergencies. So on their part, workers have the duty to, number one, ensure that his or her safety and healthy through cooperating with rules and regulations at set employee of the employer, wear protective clothing provided by the employer, refrain from eating, drinking, smoking, and taking stuff or intoxicants while on job. Any employer or worker who does not take reasonable care in handling poisonous substances and machinery, thus endangers others, is guilty of criminal offense. Like now here, you can see, fanya kazi haraka, what are you staring at? Is that your uncle? So you know that it's not allowed at workplace. Compensation and for illnesses. So I want to see how many slides are left. So Salad, up to that point, can I hear some comments, questions? Unmute your mic.
Yes, we learned more about Kenyan workers and law, and it is very explanatory.
So you've really understood what you are supposed to do as an employee, the terms of
Yes,
employment,
yes,
how you are supposed to be paid, the leaves.
yes,
So the remaining part, I've already posted the notes. If I've not posted, I'll post them on the ZDS. The
yes.
remaining notes, sija post,
Yes, ujapost hii.
naenda kuipost tu sahi. So make sure that you read, because you will realize that if you've done revision for the workshop and organization of papers, you will realize that there are so many questions that are asked on this topic. because it is a topic that touches people directly. So you need to really understand and love the topic. I hope if we stop there, it wouldn't be bad.
Yes.
So I think tumemaliza unit zetu zote za hii wiki. Sasa cuts ya mjafanya, sijaona kama mmefanya cuts mingi hapo na assignments. Na unajua naenda kuwekea watu ma zeros because they need those results. The system they're going to upload those things from the system next week. So kama kuna mtu hajafanya afanye kabla ya hiyo time.
Okay, nitafanya ile sijafanya.
Sawa sawa. So let us call it